Please rise. Circuit Court is now in session.
Have a seat, folks. Just a moment. So today at 11 o'clock, there's a further hearing on 25 CR 03118 State versus Ronald Ray Thompson, and it's here for further hearing on a motion to revoke a release agreement. I asked for the parties to send me legal memorandum, some citation to case law or reasoning in written form, and I received that this morning when staff got here and have reviewed it. I assume that each of you provided a copy of your memorandum to the other party. Is that right?
Correct.
Correct, Your Honor.
And as well, this morning, staff handed me or showed me a manila envelope with Mr. Thompson's memorandum in it, and there was also a rolled up large piece of white paper. I think that it on the envelope says map. That would be an exhibit, and there was no, and so I did not open it. The clerk kept it, and so that would be in the form of some additional document that has not been reviewed, has not been shown to the other party. I don't know what it is, and it's not a part of the evidence in this case. Not sure what I was supposed to do with it, what the clerk was supposed to do with it. Mr. Thompson.
Yes, this is a map that was provided to us by the surveyor of our easement that indicates on it.
Why are you giving it to me without offering it in court with
What?
the prosecutor having the right, a chance to review it and properly having it offered and received? You're bound to the rules of court process, as is the prosecutor, even if you made a choice to represent yourself, and that is your choice, but you're bound to the rules of ethics as well as the rules of court procedure and the law.
I understand that, Your Honor, but we're working with limited time constraints. We live an hour south of town. I had to drive this stuff in to have it here by 8 o'clock this morning for it to review.
Well,
and so
you had it yesterday at the time of hearing. You're offering evidence that was not admitted into court with proper review.
Understood. Well, if you're not admitting it, you're not admitting it. That's all there to it. It applies to many other cases here. So it will be submitted. It was given to us for this purpose. So I will accept that you're not acknowledging it.
I acknowledge that it's sitting there on the clerk's bench. I'm not, it has been offered properly or received or reviewed by the other side.
So can I offer that now and offer it to the other side to review?
Counsel.
There's that particular information here.
And Your Honor, I would just object on hearsay. It's produced by a surveyor. He's not here in court. I'm not sure what I'm supposed to do with either, but that would be the basis of my objection to admission.
nobody has offered me, there has been some written reference or oral reference to what the easement actually says. I don't have the easement in writing as an exhibit.
Your Honor, I'd like to introduce the exhibit as the easement, the founding easement is in this case in multiple filings.
Well,
In this particular one, maybe not.
In this case, not in
Well-
this case or in this hearing.
Well, I would like to offer it now because it's the foundation of all of the law and everything. Everything refers to the easement and the language in it and when it was created and the intention of it. And
That may be true, but it isn't in this hearing or in this case. You may say there's all kinds of stuff out there in Deschutes County that is pending or not, but it's not in this hearing or in this piece of evidence, except for somebody's interpretation of what that document might say and mean.
well, I have a number of copies. Mr. Fleming has seen all these many times. I would like to put it on the record here now. We're scrambling to get a bunch of copies made here. There are a number that I will give. There's
Just
The deed that-
just the one item you're trying to.
the founding deed for the easement.
Mark them as first one ever, 101, so it's clear. And what are you saying 101 is?
101 is the original October 5th, 1971 deed granting and creating the easement, along with the rest of the property.
And that's fine, Your Honor, I don't object to that.
So 101 is received. And you said there's other documents?
Yes. Okay. The second one, we would call 102, I guess, is the warranty deed, statutory warranty deed, establishing the servient property from, I think it was June 27th, 1988. And this deed confirms in its subject to items, number 4 is the easement, and it describes the easement in the book and page in the county records that record that easement.
So that's the count.
No objection.
So 102 is received.
The next deed is the deed that was recorded by Robert Kim Reid on 5/12/2021, which has essentially the same wording in it, but the wording with respect to the easement has been altered in this deed from the original. And where that occurs is, again, on the subject to items. Its format's quite different because the attorney that prepared it did kind of a different job.
So are you offering that and we'll make it 103
Yes.
and show it to council?
So the difference being in item 4, the words
Okay,
roadway, the way was left out.
it will speak for itself, but have
Okay.
council review.
Very good.
No objection.
So 103 is received.
I have one more that is the current recorded deed for our property, and it is precisely the same wording, but when I recorded it, or when we recorded it, we included an affidavit of fact in support of the attached warranty deed.
I'm not sure what the affidavit of fact is. It seems to just be Mr. Thompson's own interpretation of the deed. I have no objection to the deed itself. Would have an objection.
It sounds like there is a statement there that is somebody's statement of fact that may or may not be true.
That is correct.
So do you have an objection?
I have an objection to that. Certainly, Mr. Thompson can tell us what he thinks the deed means. His opinion in written form, I don't think, is a exhibit that should be admitted.
That objection is sustained, and 104 will not be received.
And thank you, Your Honor, that's it.
And so, question for Mr. Thompson, do you believe your deed is an affirmative deed or an affirmative easement or a negative easement?
Well, I don't see it referred to in those kind of terms very often, but it is very definitely an affirmative easement, from what I would understand that wording to mean.
No argument. Anything in addition?
So, Your Honor, I think this is fairly simple. I know we've gotten into the easement side of things, so I'll address that briefly. I think when you look at the wording of this this deed language, the exact wording says, excuse me, I'll just get it from here. Easement, including the terms and provisions thereof, for roadway purposes, 30 feet in width, over, upon, and across the easterly 30 feet of the northwest quarter of the northeast quarter of Section 25, Township 22 South, Range 9 East of the Willamette Meridian, disclosed by warranty deed recorded March 19th, 1976 in Book 229 at page 373 of deed record. So fairly straightforward legal description of an easement for roadway purposes. I think looking at the case law, if you look across Oregon case law, it's fairly clear that, as Your Honor mentioned, an affirmative easement of this kind or an express easement that's written in a deed that gives its own purpose, which is as a roadway to access landlocked property, because that's the nature of the property, as we've heard from the testimony from Mr. Thompson and Mr. Reid. No one's saying that Mr. Thompson can't use that easement. He certainly can. No one's trying to prevent him from using that easement. He can drive across that road we saw in the video. He can go out to the main road on Maston Road there. He has every right to do that, along with the folks who live at his property. His wife and anyone else who's living at his property can use the easement for that purpose. What we haven't seen here, and I think what Mr. Thompson is trying to do as some sort of defense to his violation of the no contact, is claiming that that's his property essentially in fee simple, and he has the right to exclude Mr. Reid, who owns the underlying dirt, who owns that whole tract of land. He's not supported in that proposition by Oregon law. The cases I sent to the court, and I think the cases that Mr. Thompson sent to the court, basically all reiterate that you have kind of rights of the dominant estate and rights of the servient estate, and they delimit each other. The servient estate still gets to use that property in any way as long as it does not unreasonably interfere with the use of that property by the dominant estate, by Mr. Thompson. What we're talking about here is a violation of conditional release, where Mr. Thompson, by his own testimony, by his own signature, was present at an arraignment, was ordered to have no contact directly or indirectly with Robert Kim Reid, and he did. We saw that twice in the video. We heard about further incidents that were testified to by Mr. Reid. He said 8 to 10 times Mr. Thompson has verbally communicated with him directly. It's just a clear violation of no contact with no defense, despite any claims about being what Mr. Thompson likes to term an exclusive easement. He cannot stop Mr. Reid from using that drive in a way that doesn't interfere with his use of the drive, which is fairly clear from the case law. Multiple people using a road, what amounts to an access road, is not interference with someone's easement. And so that doesn't prevent a defense for Mr. Thompson. So the state would ask that Your Honor find Mr. Thompson in violation of his conditional release agreement, revoke that conditional release agreement, and impose $5,000 to security on Mr. Thompson to secure his compliance with court orders in the future during the pendency of this case. And that's all I have here.
Thompson.
Your Honor, we have been through all of this case law. There is nothing in any of this case law that supports the state position here. None of these case laws are reflect that kind of thing at all. Even the idea of the use of the easement is never defined anywhere. How can so-and-so use it and so-and-so? We have people who literally tear up and down our easement all day long on ATVs and side-by-sides and whatnot, who do this for no purpose other than to interfere and harass with our easement. In fact, last night when we got home after court, we didn't even get all the way in our own easement, and we had Donna Reed tearing up and down our easement on an ATV like a maniac. So we deal with that kind of thing day in and day out. In terms of this Clark v. Kuhn case, the Clark presupposes a shared right-of-way. Well, this isn't a shared right-of-way. There's nothing that establishes that. Nobody even suggested or proposed any kind of a shared thing at any point in the 56-year history of this easement. It is clearly an easement that is deeded together with our property. It's attached by deed. If we sell our property, that deed goes with it. It isn't somebody else's problem to have someone tearing up and down and harassing anybody who wants to be there. In fact, I would suspect that has a lot to do with why it's done, to intimidate and discourage anybody else from buying our property should we sell it. Erickson v. Brockman, this thing's been around the mill in all these cases. It applies only to limited ingress-egress easements. It has nothing to do with people's homes or anything. It's over in the valley with the tree farm and logging equipment and all that kind of thing. It's totally unrelated. And that's one of the problems with easement case law. Easements are all different, and that's why they are defined by the document that creates them, and the circumstances around that and the language in it. And the circumstances around our easement was that it was created by my father and uncle and their wives, and my grandfather remained living on the parcel that Mr. Reid here now owns until he passed away. He built the house there and he lived in it until he passed away at 99 and a half. And then after some years, my widowed aunt sold it to Robert and Donna Reid. They fully understood what the easement was about, and within a few years, the road was cleared on the easement by my father, and it was collectively fully fenced, the entire easement on both sides, for both people's own purposes, the Reid's purpose of keeping people on the easement so they wouldn't get off the easement, and my family's purpose of securing their property because they never lived there and they needed security there. And the gate was locked with a lock at the end of by the public road that was only controlled by my parents. So it doesn't get more historically exclusive than that, because nobody else used it. Nobody else ever intended to use it through all that time. Oops, I just tapped that. So then we have State Department Fish and Wildlife versus distinction. Again, assumes concurrent rights. There were no concurrent rights. My aunt and uncle had been living up in Othello, Washington for quite a number of years. They bought farmland up there, and they had no interest in preserving road along the very far edge of the property. It was purposely done that way to not interfere with that property's use, and it never did, and it never does. The Sander v. Nicholson, the distinction. Our easement grant is not mutually limited, but exclusive. And that's the critical difference. Baldock v. Thompson reinforced that dominant and servient estates each hold concurrent rights. So the servient estate here has never established or had a right to use that easement for any purpose that the roadway purposes are meant to include. And the roadway purposes are literally the purposes, any purpose that the easement holder has for that road. That means utilities.
What does the term exclusively mean?
Well, that nobody else has the right to use it, only the holder. So let me throw you a little example here. Mr. Reid built a house. He put in a power line. Okay, he didn't put that power on the easement. If he actually thought that he owned the easement, he would have put it on the easement. We have a right to put power on our easement. One of the reasons that we didn't do that was...
How do you, from your reading of this easement, that is for roadway purposes only, exclusively roadway purposes, what would give you the right to use that easement for some other purpose?
Well,
roadway
purposes encompasses everything. Everything that the owner, the holder of that easement might have. Power lines, water lines. It was left, it's common usage because it was left to allow any foreseeable things. They didn't have fiber optic cable. They didn't have water sewer lines, but those things have all come into areas now. And that easement is to provide for all of that.
That's not what's stated in the easement.
Well, it comes under roadway purposes. Those are all roadway purposes. And those roadway purposes are defined by the needs of the easement holder.
No, they're defined by the law, not your interpretation of what the easement is.
Well, I haven't seen any law that indicates anything like that.
So you say that this is a affirmative easement, not a negative easement.
Yes. I'm looking.
Negative easement would give it only, an affirmative easement only restrains the owner it permits the owner of the easement to do certain acts on that servient estate. But it doesn't restrict the subservient estate or land from doing that.
I'm not seeing any kind of language in any of these deed documents that refer to affirmative or
You said it
negative.
wasn't affirmative.
Well, from my view, it affirmatively attaches to our property.
Well,
So maybe we need to talk about what you mean when you say affirmatively.
law says what's affirmative. So I'm going to take the matter under advisement. I expect to get a decision out. I'm going to look at these easement documents and the map that I have not previously had access to, so I can interpret what they mean. I don't think I am bound to what Mr. Thompson believes they mean, because he has his own reason for doing what for his own purposes and his own point of view. I will point out the testimony was that when this was a larger piece of property, and even when after 1971, when this easement was put in place, the testimony was everybody ran cattle over the whole piece of property, despite the easement being in place.
That is absolutely false. I have known this property my entire 77 years, and that has never occurred.
I'm talking about what the testimony was yesterday.
I never heard any testimony like that, because I would certainly disagree with it.
Well,
I know this property has been in my intimate family my whole life.
You had opportunity to refute it yesterday. But the testimony yesterday, and that is the evidence in the case, is that cattle was run on the property since 71 by the owners of brothers, their folks who were there, ran cattle on the property without regard for fencing. And were the common use of they weren't restricted, the cattle was not restricted from the easement. And so there was no restriction at that time, or it's only my driveway, nobody else gets to use it, is something that has been created because of some sense of feeling. So that's the evidence in the case.
Okay, well, if I may recall from yesterday, I believe you directly asked the witness if cattle were there continuously, and the answer was no. They were used very, very sporadically, and not since about 2005, which is 20 years ago now.
Okay, and so I guess you made my point. It's since 1971. And so when I say continuously, they may not have been there every time, but seasonally, whatever, cattle were there on the property and had full use of the property within the easement, without the easement. And so that is going to be a fact in part of my interpretation and view of the easement. Taking it under advisement, I intend to get an opinion out before the end of the week.
Well, another important point to do that is that the family members who currently own that particular property with the easement didn't own it until 1988. Because I ran cattle on somebody's land in, 1903, does that mean I have a right to it?
The easement was in place. And so you use that to look at what the intended use of the easement is and was at the time. And it was not just, well, it's my property and nobody else gets to use the property for any purpose.
I believe that the Oregon statutes disagree with that. I was looking for them here, and I'm certain I have them in that packet of information and an explanation of what they mean. There's nothing in the Oregon statutes that grant a servient tenement rights to use an easement. In fact, it's quite the opposite. And that's straight law.
I understand that's your view of the law in the situation, so be it as your view. I don't think that's actually the law. That
No.
having you said that a easement is a fee simple grant of land. It is not.
Well, I also have noted in the documents constitutional concerns. In the hierarchy of our legal system, as I understand it, the U.S. Constitution reigns supreme. There are protections for property in that. There are protections against forced association.
The grant of constitutional rights applies to all the property owners, I suppose, and so that a holder of an easement cannot force their views of property rights on the other owner's rights.
Well, those are all determined the day the easement was created, long before there were any Reid family members involved.
Thank you.
Thank you, Your Honor. Parents, I have questions about the Supreme Court order of assignment. I would like to see that docketed, if there is one, because...
You've already made your appearance in the matter, special or not, or general.
Well, we also have the matter of this case has not been commenced